organized by the Center for Digital Governance at the Hertie School. And I think nearly all of you are familiar with our format. The idea is really we invite a guest speaker, we discuss an interesting current topic, the research perspective on that. The idea is to have a presentation of 30 minutes, and then we go into Q&A. And it's a special pleasure today to welcome Giulia Gentile from London School of Economics Law School. So we will have a legal perspective about a topic, I mean, we are very much interested in. So a lot of research at the Hertie School is currently about artificial intelligence, the impact of artificial intelligence in society, but also especially in government. And you, I think, take a very interesting perspective. So that the area where probably the resistance could be as high as nowhere else, and I mean, which is really the core of government, is the courtroom. So it's this legal administration, and the question, and what we want to discuss with you and your insights from research is, so how is AI transforming the courtroom, the legal, the court system, with based on experiences, and you will present research from case studies in Estonia, UK, to discuss somehow what the implications of this new technology in the courtroom is, how fundamental are the challenges, what can we do, what needs to be addressed. And yeah, we are terribly excited to have you here with us and full your ears. As we always do, we want to have a recording of the speech itself. And then when we move into the discussion, something like after 30, 35 minutes, we then, of course, will switch off the camera. So when you join us for the discussion, the exchange, no camera will be running. Okay, Philip, anything else I need to mention at the start? Philip is our master of ceremony, somehow giving me a little bit support on that.
We're good to go. We're good to go.
Okay, then Giulia, very best. Thank you for joining us, and I pass over to you. The floor is yours, and we are really keen to hear more about the topic today.
Thank you so much, Gerard. I mean, it's for the kind introduction, and also because it's a great pleasure and honor to be here with you today and share with you some research that I've been conducting for the last couple of years. And what I can say is that there's so much happening and so much change is occurring in so many different parts of the world that is really complex, even for researchers to keep up with the speed of the change. So today, what we're going to discuss together is what is happening on the ground when it comes to courts and AI, and in particular, how the AI advancement, even in the legal field and in particular in the courtroom, is perhaps entailing a transformation of how we see the role of judges and how we as citizens perceive justice as a function of the state. So the title of the presentation is Transforming the Guardian's AI in the Courtroom. So one may think that, well, I mean, this presentation is mainly going to be about AI. And in fact, I mean, that wouldn't be, so to say, surprising. If we look at the headlines across the world, we see that in many parts of different states, of different jurisdictions, AI in the courtroom is advancing, is happening. So in these slides, I have included some examples from China, for example, where we see that the so-called robo-judge has been introduced, the so-called internet courts that are fully automated courts deciding cases in China. But we have also other examples of how artificial intelligence is shaping justice, the delivery of justice broadly understood. For example, we had a few years ago headlines concerning Estonia and how the government was planning to introduce an AI judge when it comes to small claims, so claims of relatively small nature, to deal with the backlog of cases that Estonian courts have been facing. But we also saw just a few weeks ago that in Colombia, we had the first metaverse-driven hearing. So for the first time, a court hearing was held on the metaverse in Colombia. So clearly something is happening across the world. But in reality, these changes are affecting specific jurisdictions. And as I will illustrate, in reality, the change hasn't gone as far as we would think with the introduction of a full robo-judge in all these cases, in all these jurisdictions. So in reality, apart from China, I would say, the path towards automated justice, towards a robo-judge, is very far away. And in fact, the digitization of courts has been going on for years, but there is a lot of resistance even when it comes to making courts fully automated by artificial intelligence. So I think that this is the right moment in a way for us to start thinking about how AI could shape the future of justice, in particular in Europe, where there has been a lot of discussion about the future of justice and also the impact that technology could have on government. And therefore, we are at the right moment, so to say, to critically think about the future before making any big changes. And why do we need to be critical about the introduction of AI in the courtroom, in particular when it comes to Europe, where we saw that this change has not yet occurred? Well, as formulated very nicely by Haber and Reichmann, the use of AI in government can lead to a very interesting transformation of the state. On the one hand, if the state doesn't really understand the technology and does not embrace the technology, the state can look as clunky, bureaucratic, slow, and inefficient. So in a way, the state might appear as resisting the technology, and in a way might lose, so to say, on efficiency and effectiveness. But on the other end of the spectrum, when instead the state embraces the technology and therefore, in a way, uses the technology also to empower itself to better function, well, we have the opposite phenomenon, where the state, of course, becomes tough, muscular, and highly powerful, an entity that looks almost like a leviathan, likely to overkill. So the technology, and in particular artificial intelligence, could be crucial in this context, of course, to enhance authoritarian practices by the state, and in a way could also subject courts to the power of the central government. So we need to be very careful when thinking about this transformation, this digital AI transformation for courts, and therefore we still have the time, so to say, to shape the future and think about the future. So even though, as I said, this presentation reflects on AI, in reality, we're still at an early stage, but this doesn't mean, nevertheless, that some changes are taking place when it comes to the digitization of courts. And in fact, I will illustrate, as already anticipated by Gerard and Philip earlier on, two jurisdictions, and in particular the digitization of courts that has been taking place in these jurisdictions. And I will start from the UK, and I will then look at Estonia. So in the United Kingdom, the digitization of courts has started very interestingly in 2014, right in the aftermath of the publication of legislation in 2013 that drastically reduced legal aid. That meant, of course, that public money, public funding for those who had, so to say, limited means and therefore had limitations also to access courts because of increasing court fees, were subject to further constraints when it comes to access to justice in the United Kingdom. And very interestingly, after this, after the publication of this law, we see that a narrative starts emerging in the UK government linked to the need to digitize courts. And what is very interesting is that in 2015, the Ministry of Justice and Her Majesty Courts and Tribunal Services published the response to a public consultation concerning the digitization of courts, and the outcome of this consultation provided some very interesting insights, in the sense that digitization was seen as a solution to three problems in particular. So access to justice. And one interesting argument that was advanced by the government is that, well, we have a lot of empty rooms in our courts, and this is because it's very difficult to travel. So by enhancing the digitization of courts and by making courts more digital, we would overcome the issue of traveling to the courtroom. And this would basically allow us to also rethink how we use public rooms also in tribunals and courts, which I thought was a very interesting argument for digitization. The second solution that digitization would have brought is that, well, in principle, digitization can make access to justice cheaper. So there's an issue of value for money that could be addressed. And in the long term, the third argument for digitization is that it would increase efficiency for the justice system. So these were, so to say, the arguments submitted by the Ministry of Justice, even though, as I said, just a few years beforehand, we saw a drastic reduction of legal aid and therefore public financing for access to justice. And also what is very interesting is that there seems to be also another narrative that permeated the digitization of courts in the United Kingdom. And I think it's very nicely encapsulated in the in this quote by Sir Geoffrey Voss, who used to be the Master of the Rolls and head of civil justice. And he basically made the point that we need to digitize courts because there is a technological global change that affects companies such as Amazon, Netflix, Google. And this means that UK courts should increasingly use technology such as blockchain. So basically, because the private sector is becoming more digital, then also the public sector should digitize, which I thought is quite interesting as a perspective. But now going into what is actually happening on the ground when it comes to UK courts, well, as I said, in reality, the path towards AI in the courtroom is still, I would say, very complicated and to a certain extent also quite far away from us. And in fact, the aspects of the UK courts that have been subject to digitization are in reality quite limited. And the digitization of UK courts has affected in particular family courts as well as county courts. So, and I will explain in particular, focusing on county courts, how the digitization has occurred. But this means that at this very stage, in this very current moment, the digitization of justice in the United Kingdom is still very limited. But we need to be careful nonetheless, because we have also extensive digitalization plans for UK courts that have been presented quite recently by the UK government, which means that it is still likely that AI may be in the near future introduced in the courtroom in the United Kingdom. And now I would like to introduce to you one of the digital, so to say, aspects of the UK court system, which is the money claim online. So this is how it looks like. In this slide, I have included the portal. And this is a system that was introduced since the 2000s, and a pilot has been then rolled out since 2017 that allows individuals to bring money claims through an online platform. According to the plans of the UK government, there will be also additional layers to this technology. There will be a second stage where basically the portal will also allow mediation and case management. And it would be very interesting to see whether in the future there would be an AI element to, for example, the case management. And finally, there will be a third stage with a determination of a judge regarding the money claim. And also there, it will be very interesting to see whether in any near future there would be any form of AI element to this platform. But what this platform does for the time being is simply issuing money claims, allowing parties to lodge a claim that will be then processed through the platform and then will be subject to a decision by a judge. So for the time being, just to be absolutely clear, there's no, strictly speaking, automated decision making, but in the future, this may well be introduced. So what is then the advantage of this system? So when we look at what might be the advantage of having this more digital-driven platform, we can observe some interesting things. So first of all, this platform may be cheaper in the sense that there have been studies that have shown that if an entity, let's say a law firm, is, for example, engaging with money claims on a regular basis, having the ability to access this online platform can be cheaper because, of course, there is less paperwork, it's an automated, so to say, procedure. And in a way, this can allow the applicant, let's say the law firm, to save money from the perspective of lodging the claim by simply dealing with the platform. So there would be, so to say, there would be a saving of money in terms of time, in terms of potential costs related to paperwork, as well as, so to say, workforce involved in lodging the claim. There are nevertheless some limitations in the sense that, for example, through this platform, applicants cannot seek legal aid, which, of course, is quite problematic in the sense that if this platform is cheaper, on the other hand, though, it doesn't allow individuals to avail themselves of legal aid. So in a way, this can defeat the very purpose of making a cheaper platform for certain categories of applicants. Also, there's another issue that the registration platform is quite cumbersome in the sense that before accessing the platform itself, the applicant should register. And this actually is a quite lengthy process that might not necessarily bring any concrete advantage. And then there are also very interesting problems that emerge in this context, basically linked to the fact that it's very difficult to, so to say, describe the claim quite carefully in the sense that the platform only allows a limited amount of characters. So this is a challenge for the applicants to explain why they have brought the claim in the first place and what is the legal basis on which they may claim this amount of money. And also what is quite interesting about this platform is that if the defendant fails to submit its defense through the platform, the applicant can request a default judgment. So again, let's imagine that the defendant may be a person that is not really tech savvy. Well, there is clearly an imbalance between the parties, and this can lead to an unfair advantage for the applicant. Now let's move on to Estonia. So what is happening instead in Estonia? The system is very different, as I will explain in a second. But in this slide, I have included a chronology of the different technological, one can say, advancement in the court system in that jurisdiction. So everything started in the early 2000s. And in a way, what is quite remarkable is that the digitization of Estonian courts worked in parallel with the accession, to a certain extent, of that country to the European Union. And this was, so to say, marketed by the Estonian government as one, so to say, of the ways in which the Estonian government wanted to make Estonia a more efficient country. And starting from the 2000s until very recently, we see that the government has introduced several court information systems, and in particular the KIS system that I will describe in a minute, that has allowed the centralization of documents used by the courtroom, and has also facilitated digital communication between the participants of court proceedings. As I said, in the UK, the digitization has affected mostly the first instance courts. So we talked about the family court and the county court, the online money claim system belonging to the county court system. In Estonia, instead, we have a different trend for digitization. Everything started from the highest court, the Supreme Court, and now we see that the digitization is, so to say, working as a cascade. It's also affecting progressively also lower courts. But everything started with the Supreme Court. Why? Because the Supreme Court has, of course, a more limited number of cases, and this also therefore facilitated the testing of the technology, and in a way also allowed the technology to be improved with the input of very senior judges sitting at the Supreme Court. So this is a very, so to say, interesting approach, and also very different from the United Kingdom, where we see that the supreme jurisdictions are in a way shielded from digitization for the time being. So, but of course, also in Estonia, we see many problems, even though the digitization started from the highest court, so to say. So what I would like to discuss in particular with you is the KISS system, which is the acronym for the Court Information System. This is an Estonian acronym that is an information management system that, as I said, was introduced initially at the Supreme Court level, and now is progressively also introduced in the first and second instance courts. So what this system entails is basically that all cases will be registered online, and through the e-file, they will be then allocated to the different court system. But also, quite interestingly, there's a connection between the e-file system and courts, as I said, but also the police, the criminal case management register, and the office of the public prosecutor, and the prison system. So basically, this is a system that covers all the case management for the entire Estonian court system, that in a way also streamline also the allocation of cases. It also streamlines the notification system for the parties, as well as the publication of judgments. So we're still, so to say, at the management case level, similarly to the UK system, we can say, even though this model is much more spread in Estonia and is used not only for a specific claim, but in general for the court system. So what is the perspective of the Estonian government when it comes to this digitization process, and in particular the KISS system? According to the government, there are clearly some key benefits, in particular the fact that it is possible to save cost and time, that in a way the delivery of justice can become more efficient, and in a way some very manual procedures, such as that of issuing, for example, notification for the parties, or writing the file, so compiling the file for cases, as well as, for example, the transmission of files from one court to another. All these procedures, well, have been automated. So certainly this has made the delivery of justice more efficient. Another very important aspect that is highlighted by the Estonian government is that the system also facilitates the automatic generation of documents. And in fact, Estonia ranges, so to say, among the highest performing countries in Europe when it comes to justice. It is the fastest court system in Europe, as indicated in this slide. So Estonia clearly has dealt quite well with the backlog issue that it presented at the beginning of the early 2000s. But what I want to share with you is also a perspective of a judge, of in particular an Estonian judge. So I had I was very lucky. I had the pleasure a few weeks ago to meet several judges in Estonia to discuss about the digitization of justice in that country. And it was very interesting to hear their perspective on these on the KISS system. So many judges actually complained about the system because they argue that it's a lot quicker with the paper file. Why? Because the document that appears on the screen is quite long and they have to scroll through the document and might not necessarily be faster compared to a paper document where instead the vision of a judge might be, so to say, much easier and less, so to say, dependent on scrolling a document on the screen. Also very, very interesting, many judges reported that there are issues with ID access. So in order to access the e-file system, there is, of course, an authentication portal. And what they reported is that there's a glitch in the system. So in almost all the times in which judges try to access the authentication system, the system will say that the authentication has failed, even though the password and the user ID are perfectly correct. So there's clearly a glitch in the system, and that has never been fixed. And this, of course, can create anxiety among the judges when they're approaching to enter the system, the e-file system, because they think that they don't know whether this is actually a real problem or something that after 2-3 attempts to log in will be solved. So clearly this does not necessarily enhance efficiency. Then in general, what judges complained about is a lack of trust towards the machine, so to say, towards the computer and the e-filing system. And in general, another very interesting remark is that, well, the advancement of technology in Estonian courts made judges heavily reliant on the IT teams. So judges now depend on IT systems and IT teams whenever they have a problem with this portal. So in a way, the judge does not feel able, as in the past, to be, so to say, the master of the courtroom. It almost feels like the IT teams are deciding the future of justice. So I thought that these perspectives were very interesting. Now, focusing about AI. So as I said, this is what is happening on the ground in these two jurisdictions, which are actually the most technologically advanced, we can say, from a digital perspective in Europe, are really among those countries who have really invested on digitization of courts. But now thinking about the future, thinking about the possibility to introduce artificial intelligence in the courtroom, well, we can have different forms of AI in the courtroom. So we can have artificial intelligence used by court administrators. Think about, for example, facial recognition technology that could allow the authentication of the parties to the tribunal, to the court. AI could be used by the litigants. Think about the metaverse in Colombia, right? That was, in a way, artificial intelligence used by the litigant and by the court. AI could become the court, where we have algorithms deciding cases, but we can also have algorithms supporting judicial decision making. And we can have two models, in principle, the human in the loop, where human judges are required to select and guide the inputs of the AI system, or instead human on the loop, where instead the tool the AI tool works in an automated fashion, but humans are needed for the final execution, for example, of the decision. And we can also think about how AI could be used at different levels of the judicial system. So it could be used, for example, at the first, in a very first preliminary level to compile, for example, available dispute to, for example, streamlined research tasks. Or it could be used on a more advanced level. For example, we can think of simple algorithms that could be applied to various rules in relation to multiple factors. So very simple, we can say algorithms based on tree decisions that could be used already for a soft, one can say, judicial decision making, or we can have instead fully fledged, one can say, application of AI, where instead the decision is taken almost exclusively through automated means. And this is a classification that is offered by Morrison and Harkins in their paper from 2019. So we can think of different ways in which AI could be used in the courtroom. And we have already some emerging examples, one can say, of AI applications, not necessarily in European courts, but in the United States, sorry, we have a e-discovery system that is used for automated, for example, investigation of electronic information for discovery before the start of the court procedure. We can think of also prediction of decisions. So this hasn't really been used in any court yet, but we have a very interesting study conducted by UCL researchers on the decisions of the Strasbourg court, where AI was used to predict decisions of the Strasbourg court. And again, as I said, in China, we have decision-making that has been fully automated. As already mentioned, the Hansu court or the internet court uses algorithms to decide cases. So clearly, these are possible evolutions also for European courts in a way, not just in Estonia or in the UK, but also beyond. But what all these changes are entailing, in my view, the advancement of technology, the advancement of digitization, and in particular the advancement of AI are putting pressure on courts. And this is because these technological changes are transforming in a way the role that guardians, that judges have in our own society. And I think that this transformation is occurring, at least in my view, on three levels. So first of all, the advancement of technology and even more the advancement of AI in the courtroom is transforming the internal perception of justice, how judges see themselves as the body, the public body that delivers justice, but also in a way how basically judges perceive the functioning of courts in the delivery of justice. So in a way, what this advancement of technology and AI is doing is also to reshape in a way how much input the judge should provide to deliver justice, as well as how much technology instead we need to achieve justice. And this inevitably also reflects into the public perception of justice. And in a way, the pressure that this technology advancement is putting on courts creates a tension between how the public would like to see justice delivered. And there's a tension, in my view, between the need to make justice more efficient, more effective, but on the other hand, there's also the problem of trust, whether we want to give courts that are driven by AI the power to decide on our rights, on our legal entitlement. And also, the third transformation that I can identify already at this stage is what I call here as the epistemology of justice, in the sense that the introduction of technology in the courtroom is in a way broadening the knowledge gap between the public and the court, because of course there's an additional layer of complexity in the delivery of justice being the technology, but in a way it's also creating a knowledge gap between the judge and the technology, because judges are not trained, of course, to understand the technology. So in a way, we're making justice less understandable, not just for the public, but also for the members of court system across the world. So the question is whether this technological cultural change will lead also to constitutional change regarding how much technology we will embed in the courtroom. And now we're coming really to the end of the presentation, because I think that in thinking about the transformation that we might want to accept as a society when it comes to embedding the technology, and in particular AI in the courtroom, we should go back really to the basics and think about what judges do. And essentially what judges do is providing a service that of adjudication, in the sense that the public service of adjudication is the crucial function, in my view, of courts. And we have different views on adjudication, but I think that what is quite interesting is that it is based in any way on the idea that there will be a reasoned argument. There is an element of reasoning, there is an element of rational thinking that allows the addressees of a decision to understand also the process through which the judge has achieved a specific outcome. And the constitutive elements of adjudication that I've included in this slide are a multilateral understanding, so the ability, of course, to understand, as I said, how a judge reached a certain outcome, trust, but also participation. And one can wonder whether also humanness is an essential element of adjudication. So in my view, I think that we should start conceptualizing, or at least we should try to protect adjudication as a public human good. And why do I think that humanness, to a certain extent, is central to adjudication? First of all, because, as I said, judges are guardians. And because of this role as guardian, they have in their hands two very important, one can say, arms, weapons to a certain extent, which is legitimacy, in the sense that judges, human judges, are perceived as legitimate because of the powers that the constitutions across the world provide to judges to carry their judicial power to conduct adjudication. So in a way, legitimacy is intrinsically linked to a human judge. And also, what is very important is that judges also are crucial for the separation of powers. And inevitably, they act as, in a way, a counterbalance to potential abuses of powers from the government, from the central state, even though, in fact, the government represents, one can say, the people agent. Not always the interest of the government may be aligned with that of the people agent. So courts, in a way, can work as whistleblower for any misconducts of the government. And they also carry a very important function that I would see as very difficultly carried out by an AI system, which is that of signaling unlawful conducts by the government, as I said, but also allowing, as a result of a judgment against, for example, a public authority, the coordination among the public to reform perhaps specific aspects, specific legislation, specific aspects of the constitution, specific legislations used or introduced by the government. And in my view, there are two points, I think, that stress the importance of humanness in this context, which is, of course, the constitutional argument. The Constitution, of course, gives power to human judges to carry out their role as guardians of our systems. And also, I think there's the sameness argument in the sense that as we want to be represented by human politicians, we would also need inevitably human judges in order to, so to say, feel the trust and also to feel the protection of someone similar to us dealing with legal disputes. So here I conclude. I'm so sorry, I realize I went slightly over time, and I'm very much looking forward to any questions you might have.
Thanks a lot.